Welcome to another episode of the Property Nerds podcast, and today I'm really excited. We've got a special guest, and that guest is Joseph from KGCO Legal. Trust me, it gets very exciting. Tune into this episode to know how far your legal partner or a conveyancer you work with can really take it to get you the win you need. Also, the mistakes that you can avoid ahead of time when it comes to SMSF, specifically from the legal and conveyancing side of things. So tune in, let's get into it.
Nerd Alert! Property Nerds, the home for data-driven property investors, where we uncover Australia's hot and cold markets, latest headlines and trends.
Joey, welcome to the show, mate.
Thanks, mate.
Over 10 years knowing each other now, from our time back in the finance world to property and then collaboration at InvestorKit. I wanted to know, what actually initially got you to pivot from the finance world into the space?
Mate, it has been 10 years. I'm curious. We haven't killed each other yet. That's amazing. You know what? Someone told me ages ago to start off in finance, even though I was studying law. It was a mentor of mine. And the best way to do that was to start off in the branch. Because you deal with so many different types of people. That probably was really good in hindsight from a legal career, because you're able to deal with so many different people and so many different people from different walks of life. And in terms of a customer service perspective or a client management perspective, that equipped me beautifully. I was simply just doing that during my studies, and it was great. And then I transitioned over to the dark side. Being law, solving people's problems, trying to solve the world's problems in one day.
Yeah, I mean, like, our relationship goes way back, and I know the guys here at InvestorKit and Foraker Financial, Jack and Adrian, know you pretty well, but we've been knowing each other from like over 10 years now. Started off with gym buddies as well, actually, back in the days.
Yes.
So a bit of a change now, but mate, Jack, you got some strong thoughts on the conveyancing world as well.
Man, I have a running joke saying that conveyancing is boring. I don't know if anyone's going to listen to the podcast. But
Jack.
Sorry, mate.
Jack, I pray for a boring deal, mate. The boring deal is a good one. Boring means I can go home and see my kids, mate.
That's it. I think boring's what you want in that, because it's smooth, right? But at the same time, if people don't know what they don't know, and we see a lot of things, like, this stuff catches them by surprise, and especially in that legal world where they're not aware when they're buying an expensive asset. It's $500,000, $600,000, $1 million plus, and lots can go wrong. So I want to know from you, Joseph, I think to really help some of the people listening here who are on their property investing journey, what are some of the mistakes you see specifically in SMSF? Because this topic has come up heaps. Yeah. People are setting it up more than ever. People are more interested in taking control. They're basically going, I want to take control and continue to use leverage and property investing as my vehicle. What are you finding as some big mistakes on that legal side that people make often?
Just on a basis surface level, the implications of putting your pen to paper on a contract of sale of land in any state are really severe. And if you haven't sought legal advice before doing that, you're not just signing some gym contract, right? It's there are real implications, and when you get tied into a deal, and most deals can go unconditional straight away. And for those of you who are listening, don't know what unconditional means, is once you sign, the deal's going ahead. There's no subject to pest and building, subject to finance. So once you effectively sign that contract and you're committed to that deal, you're facing a lawsuit if you want to get out of it effectively. And if you're not seeking legal advice before you do that, you need to know what your bottom line is and what the risks are. And every contract's different. Not every contract is standard. You might come across standard contracts, but there are special conditions in there that are all bespoke to different lawyers and different firms who have prepared that document. You need someone to take a look at it. You need a human being to sit there and take it through it. And that's what we do. Yeah. Turning into the SMSF, well, that's SMSF sphere and those types of deals. Well, that's a totally different spectrum. I think the main 2 points there are generally with registering a bare trust deed. As you fellas are probably aware, the self-managed super fund can't actually hold a debt. So you need to set up a whole nother trust to hold the property until that debt clears, so that property can then be transferred over to your original SMSF fund. Setting up that bare trust differs in every state in terms of the timing of signing each document. How to register it, when to stamp it. If you're not seeking the advice of a professional that's well versed in that state and setting up those documents, so accountant, you run the risk of getting that document wrong, which means, and there's a massive implication of getting that changed, because if we tie back in, once you've signed that document, signed the contract of sale, you're already tied into the deal, and it's not it's not a straightforward process in changing the purchaser name.
Mate, the amount of times I've had a client send me a contract to sell with the trustee company of the SMSF, like it's unbelievable. So who's responsible for actually telling them, hey, you can't sign the contract yet, you've got to set up a bare trust? Because like I find that when people don't use a team, like they don't have a buyer's agent, they're just doing it themselves, they'll just sign a contract and think that the SMSF trustee company goes on the contract.
Yeah, right.
I've received so many of them, man. And we've had to get it changed. Like the other side, the solicitors, they don't have to like help you kind of exit that contract and re-enter it. But I guess that's the only way around it, right?
Well, I mean, if you're just going to pinpoint responsibility, you'd look at you'd look at the person who, or the entity, or the individual.
The sales agent just wants them to sign the contract, right? And the person who's buying, if they don't have a buyer's agent and they're just saying, yeah, I've got to do it in SMSF, and you know,
who told them to get it through an SMSF?
Oh well, like if they've already pre-approved, like.
Right,
you know.
but the strategy of purchasing it in an SMSF, it's probably come from a financial advisor, right?
Yeah, so it's kind of like who started it.
Who started it, and they should be the ones telling you where to go. If you're going to pinpoint responsibility, I don't really approach it like that. If someone comes to me and they're purchasing in an SMSF, I have a set of questions I'll ask them. So, look, you know, does the SMSF, do you intend to get a loan? Right, first question. If you're not intending to get a loan, put the SMSF on there, because you know the fund can purchase it straight away. But if you're getting funding from a financier, then we need the bare trust, and that's like 99.9% of the time funding is going to be a thing, right, from a financier. So I'll ask for the bare trust. Tricky situation, we'll probably get onto this in a minute, is we don't have any, we won't know if it's just a proprietary limited company purchasing the property. The only way that we can pick up on those flags is if it says SMSF in that name. Otherwise,
it could just be like a company purchasing it, and like no one has told you unless they actually, you know, unpack it more and things like that.
Correct. So, you know, we need to diverse in that. Something like when we do deals with your team and your referrals, we know because your team lets us know. But apart from that, you know, it becomes a bit of a nightmare finding out once we've gone on con.
Yeah. Well, my team picks it up now straight away. Like we know to check that straight away. It's like make sure it's not the SMSF trustee company, but it's actually a bare trust.
So like the name is obviously one part, right? That's becoming an issue where in SMSF people keep getting that name wrong, the entity wrong, and it just differs from state by state. So what we want to like understand is like, hey, if you're a property investor, the first part is you've got the state of purchase. Now you also have the pre-approval. And then you've also got the accountant or the advisor advising you on like what to set up. It's making sure those three are linked by the original person who's going to not only manage the setup of it, but the ongoing admin and compliance for you. And that is usually your accountant or advisor. So if you're going to come back to them, I think that's a real good starting point with it. But Joseph, beyond the name, you also see some other issues in SMSF. Me and you talk about it often, and it's like people not knowing what to do when loan docs come around and how that differs. Or just different, you know, states. Like, how does that work when we get to loan docs? Because this is a different part, and I know you and Jack can talk to this a fair bit.
I think step one, best case, find the right accountant to set up the bare trust deed.
Yeah.
Step two, find a suitable financier or broker to generally give you good expectations on what to expect once your loan docs come. You know, sometimes I find myself in a bit of a sticky situation because financiers expect you to obtain independent legal advice on pretty much every single SMSF deal, but they only find out once they've gone unconditional and they've got their unconditional approval from the bank, and then they're like, "Hang on, I need to get
scrambling now, right?
Scrambling, one, and two, additional fees, because that's not covered by a conveyancing service. Our team then needs to review the entire loan document and provide an advice on that, and then advise the client and sign off on it. And look, that might sound like a mundane task, but because we are signing a statutory declaration or a legal declaration confirming that we have advised on the document, it means I have to spend the time, and my team has to spend the time by reviewing the loan document and advising on the same. And yeah, we do review those loan documents all the time, right? And it is a mundane task, but if we're signing off on it, it means that we're willing to declare that in court, which is something we take very seriously, which is why, you know, there's an additional fee. Some clients find that fee hefty, but it's just because of the time involved, right? But I think the main trigger there is to let them know to expect that. So we do that. We let them know, look, your finance is likely going to require you to obtain legal advice. This isn't included in our scope of works. Bang, that's a light flicker for them. They know. It's
that foresight, right? Because I think where mistakes happen is when you don't have foresight. Yeah. It's like you're coming into a journey of thinking, oh, let me just buy property because it's a property. It's the same as everything. It's just a name on a piece of paper.
Yeah.
And then you go, well, the name is different in every state, depending on what you had, a loan or no loan. So you've got to make sure you get that right.
Yep.
And then it's like, well, you've got loan documents that are not going to be just sign them and send them back. You've got to get separated legal advice on them, and the banks are very particular. So I think the main thing property investors need to get out of this is get that foresight on what the deal has to have in terms of all these boxes to tick in SMSF, because it's clearly different.
Well, here's the kicker. And this might be my little personal crusade with the banks that I'm trying to put aside and just move on with life. But
that's that ex-banking life coming back into you, right?
They require you to get a legal advice after they've given you an approval. They're like, yeah, sir, madam, here's your loan. We're going to give you the money. But before we give you this money, you got to go speak to your lawyer and make sure you're happy with us giving you this money.
Yeah.
And then if I'm the client, I'm sitting there, I'm thinking, all right, cool. But I committed to the deal. Remember, run it back, right? We've already signed.
Yeah.
We've gone unconditional. Make me get this legal advice before you want to give me the money, just in case. What if I don't like what my solicitor tells me? Yeah. 9 times out of 10, everyone understands that they're ultimately liable for the loan. But end of the day, you'll get that odd person who might not. Who might not like that, and then they're like, you know what? I don't want. What if right? They don't want to proceed with the finance deal anymore. I'm like, mate, lesser of two evils. Take the money, sign the thing, because the vendor's going to bloody sue you.
Yeah. Because it's not like they declined.
Well,
they got the approval for it, right?
Correct.
So it's
and
like
the financier puts
approved.
them between a rock and a hard place. But even if they've gotten the approval, we've satisfied a finance condition, or we've expired a cooling off.
True.
So you're committed. Once it's unconditional, you can't back out unless there's some major issue with the way that the vendor's solicitor has prepared the documents and it's in line with the legislation regulations, that then we can back out of the deal. But you're throwing a Hail Mary in the Super Bowl for that.
But it's a physical document too. Like that's the thing. Like loan documents can be signed digitally and it's done. But if you've got an independent legal advice certificate and you're interstate to the customer, then you've got to send it to them. They're going to send it to you. Then you're going to send it to the bank. There's
provisions under the Electronic Transactions Act in Victoria and New South Wales that permit e-signing and e-witnessing different documents, and also the Oaths Act in Queensland. They allow you to do that. But take
changing with
the
times now. Finally, right?
After COVID, and then everyone just implemented that law after COVID.
Yeah.
But I take your point. It is annoying why we can't do it via DocuSign.
Thinking about your next move in property? Before you act, get the facts. InvestorKit's white papers are actually packed with the kind of insights most investors just never see. From detailed market analysis to investment strategies that actually work. Whether you're eyeing residential or commercial opportunities, these reports will help you make smarter and more confident decisions. Head to investorkit.com.au and download your free copy today. Link in the show notes.
It does get hard, honestly. Like even myself personally, not within SMSF, but just within trusts and everything, I've had to do it as well.
Yeah.
Back and forth, mailing documents, just waiting for it. It does take a little bit of time. And Jack, you'd also know as well, that makes it really hard for us to hit the deadlines that we need to.
Yeah, especially if they put it off.
Adrian, you know, the funniest thing you just made me think of then is that imagine there's a term you don't like, Joseph. Like, who's going to win the battle against the bank to go, oh, thank you for the loan approval, but clause 3.C,
I don't like it.
I don't like it. Can we please change this?
You might have a legal argument there, but you can never interfere with someone's commercial decision to lend you money. You can't never. There's always something you can do, but it's like you said, it's an uphill battle. If the bank doesn't want to give you money, like point in case, right? So you probably have a legal point, a legal leg to stand on to say, you know what, I don't have time to get my solicitor to wet sign this. DocuSign, take it or leave it, right? It's in accordance with the Electronic Transaction Act. You can't really say anything about it. It's I've admitted to signing it. They've admitted to, my solicitor's admitted to signing it. Just cop it on the chin. The bank will go, well, no, we want a wet signature.
Yeah.
We're not going to give you the money if you don't give us this. What's the court going to say? You have to give them the money? Oh, I mean, there's a representation argument or a misrepresentation argument or potentially an argument of estoppel, I don't know. But leaving that point aside, I mean, it's a headache in itself to actually go down that path. And also, again, my commercial decision to lend you money is on my terms.
It's like take it or leave it kind of thing. It's not really a...
Dude, you want this money? Take it.
Yeah, it's not like, have you seen advice to now change it and let's enter a back and forth? Side note, if you haven't already, South Park, there's an episode on T's and C's with Apple, and it's the craziest episode ever.
Can I see it?
Yeah, I encourage everyone. If you're having if you're nerding out with us on T's and C's to do with like SMSFs and loan advice and mistakes, go watch that South Park
We're allowed
episode.
to talk about South Park.
Probably not too much.
I'll go down a
This is
rabbit
your
hole on
brother's
that one.
influence.
Yeah,
Getting
this is
into
my
South
brother's
Park,
influence of me and South. But yeah, go check it out. T's and C's Apple. That's the worst episode ever on this. Yeah, look, I think it's a really good insight into some of the mistakes they're made and how people in the SMSF space need to consider that.
Yeah.
We were talking about different states earlier before, and I think what we are kind of seeing in the business as of right now, or is becoming a lot more prominent, is the whole concept of interstate investing. People
big one.
investing outside of their backyard and everything like that. I think what would be really interesting would be to jump through a couple of states and really just highlight the differences. I know we kind of went into it a little bit within SMSF, but maybe just more generally between the different states of, let's call it Victoria, New South Wales, Queensland. What do you really see as those key differences between purchasing in those states?
New South Wales and Vic are quite similar and quite stringent. Queensland's the Wild West with sheriffs, cowboys and Indians all shooting at each other at the same, not knowing who the bad guy is. Effectively, New South Wales, you've got a 10-day cooling off period.
Yeah.
You can sign a contract, but it's, depending on whether or not, I know the InvestorKit way is effectively buying something that's not at an auction, right? But if you are,
Look, time to time, it depends on the
comes
asset.
up on the
but
odd occasion.
mainly prefer not to if we can negotiate really well, but time to time.
and that's because once you negotiate at an auction, it's take it or leave it.
Yeah, it's unconditional.
Yeah, so there's no cooling off period, but it's unconditional like that in virtually all states, right? Unless there's some sort of special condition stopping that. But no one will go to auction without an unconditional exchange on the day. But without going on a tangent or a red herring here, the New South Wales sphere gives you a 10 business day cooling off period. You can pull out of the deal anytime you want for any reason. You don't like the smell of the basement. You can tell the vendor to get stuffed. Like it's completely up to you, right? Vic, and again, after that cooling off period, you're committed. Vic, a little bit different. You got a 3-day cooling off period. Again, the smell in the basement, you can only rely on that for 3 days. Then after that, it gets considerably more difficult for you to back out or get cold feet on the deal. Meaning, you got a pest and building condition and a finance condition, depending on how long the contract states. Pest and building set as 14 days if there's not a special condition that amends that, and then you set the finance date. One finance date in Vic's a little bit different, where you actually have to show the vendor that you've done everything reasonably possible to obtain finance, meaning like you can't just say I didn't get loaned because I forgot to submit my application.
Yeah,
You've got to
it's
show
like
that
you gotta
submitted
ask your
straight
uncle.
away. You've done everything. You've done everything you can, right? And that's that's really an objective test, right? So, what I think is doing everything reasonably possible compared to what you think being done reasonably possible may differ, but you generally have to just apply a rule of thumb of what you think is reasonable. Don't wait until the last minute or ask your uncle for the cash before the day before the end. Then the pest and building. So pest and building, the objective of that clause is just simply to ensure that you're not buying a property that's structurally compromised, right? So it gives you an opportunity to obtain a pest and building report from a licensed building professional and licensed pest inspector to confirm that there are no major structural defects or no major pest infestations impacting the structure on the land.
So that's really frustrating, eh? That clause
If you've got a tree out the back that's got a pest infestation, you can't do nothing.
Yeah,
about
and
it.
that part's frustrating in Victoria. We see it all the time when we speak to clients. It's like you could have death by 1,000 cuts on minor defects.
Yep.
Nah, and it ain't going to work. You need major defects
Correct.
to be able to use that clause. So do you reckon there'll ever be a day where it's a federal contract, like it's just the whole country? It's not like state by state by state, all these different laws, settlements, like... That's like the easiest way, right? An Australian contract to sale to buy a property.
How long do we have to have a constitutional discussion? And are you keen?
Someone give Joey a cigar. Let's talk about this, huh?
I have to invite a couple of boys at the back at the boardroom, sipping cognac, and we'll have a real intellectual discussion. Or if we have a dictator that just runs the country by military force.
Oh man,
do I think that'll ever happen? I suppose not, to be fair.
How easy would it be if all contracts were like one contract, right? Like follows the way, like make life so much easier. Queensland.
Yeah, but then I can't charge all different fees.
Yeah. Here we go.
Guy's got to eat, mate.
No, but Joseph, so that actually is New South Wales and Vic covered off. I want to understand Queensland though. What's the core differences there?
Cowboys and Indians and sheriffs killing each other, not knowing who the bad guy is. It's a little bit different. Finance, you can simply just email the other side and say we haven't achieved finance by the due date, or even better, the pest and building condition says that this contract is subject and conditional upon the buyer obtaining a pest report that's satisfactory to them.
Wow. So
and they have to act, the only obligation under that clause is they must act reasonably. And let's tie it back. What I think is reasonable may differ to what you think is reasonable, right? So, you know, I don't know if this has ever gone to a judge yet or gone in front of a judge. It probably has. It's just not on top of my memory. But if a judge is looking at a case where vendor's trying to make the purchaser commit to a deal, the judge is looking at the issues as to why they put out under the pest and building is because the lawn's not mowed. I'm not saying you'd win or lose on that case, but someone's going to get pissed off looking at it wasting everyone's time in the Supreme Court.
You must see some crazy stuff, right?
Yeah. I channel a lot of my anger actually when I act for vendors in that scenario.
Yeah.
I think I've used it as a case study of what not to do for a buyer. Like 10 minutes before settlement, asking for someone to mow a lawn and and clean a basin sink. Like, I remember there was about $200 we were arguing about minutes before settlement, and luckily my client decided to dig her heels in. I told her, look, the legal advice here is just pay the $200 and let's get on with it, right? But if you don't want to take the legal advice, I'm happy to be your attack dog. And she goes, all right, go for it. You know what? No, we're digging our heels in. And look, there's a bit of history to this matter. You know, the buyer was being unreasonable the whole way through and wanted everything done, everything fixed. Then right at the 11th hour, I'm like, you know what? Screw it. I'm ready to see you in the Supreme Court over $200.
That's the dog you want in your corner, right?
And then when I win, you're going to pay my fees.
That's unreal. That's unreal.
Because ultimately, you know, you can't be asking for all of these things once we've gone unconditional. And once you've gone unconditional, mate, committing to the deal, effectively, you're not 90% of the issues that occur within the property. You just got to accept it. And I like to say this to my clients in a respectful manner. Like, if you're investing in property and this is concerned, things like this are concerning you, then respectfully, if it is too hot, maybe get out of the kitchen. If you're not up for these sort of surprises, this is not financial advice. This is just general advice from your solicitor. There are going to be more surprises in the future that you're going to have to cop. Right?
Always like prepare for the worst case.
Fact. Yeah. If this is an issue for you now, then it's going to be an issue for you later. Maybe you're not in the right sphere, but that's not my business. And then as soon as they realize that, they're like, oh, okay, cool. Yeah, you know what? You're right. I think I'm focusing on the wrong things right now.
So you've been in the game long enough, man. Do you have any other crazy stories for us?
Oh, he's a story bank. Get deep.
I've got stories for days, but I don't want to be breaching client attorney privilege at this point in time.
Such a lawyer thing to say, hey. Like, just like,
I feel like I heard that on
I don't want to breach these. And like,
I feel like I've compromised myself in this already in this podcast. It's all right. Val came back during finance under purchase price significantly. It was like 70, 80K.
Yeah.
So, you know, the vendor just got what they expected absolutely wrong. And a negotiation took place, and the basis of that negotiation was effectively like my number is the bank's number. Like my client's number is the bank's number. We can only meet you at what my bank's willing to lend my client, right? Otherwise, we won't be able to satisfy the finance clause. I think the kicker on this one was a well-written letter. So I believe that if I was to send just a one paragraph email on this point saying, hi, dear colleague, see attached valuation. We can't satisfy finance clause unless you drop the purchase price to X amount. Well, no, I got my client to get 3 different vals from the bank.
Yes.
We also got an RP data property search, and we started to tell a story in the letter. Right.
Yeah.
A 2-paragraph email became a 3-page letter.
Wow.
And I'm explaining, right, we've got these valuations, but you know what? Just to show that we're not being greedy here, we're going to adopt the highest val from the banks that have returned, just to show that we'll take any offer here that the banks are giving us just to complete this deal, right? Yeah. And then we say, we fail to see how you can not accept this offer when, if we terminate, you're going to go back on market and another buyer at the same purchase price that you want is going to face the same impasse that we're facing right now. Do the deal now, otherwise, you know, you're going to be faced with the same issue in the future. Mate, 60 grand off the purchase price.
That's huge. Well done, mate. Well done.
Yeah,
that's
that
unreal.
was pretty cool.
These stories and like just today's episode, like SMSF, core mistakes, the things that you don't want to make. and just making sure you get this name right, like get the ordering of where your advice comes from right.
Yeah.
But then also just from like the foresight you're giving buyers today in terms of when you're in SMSF, the contracts to consider, the legal advice and things like that. And the friendly tip for me to go watch a South Park episode. But then understanding different states, mate. And just
don't watch The Sopranos.
Yeah, don't watch that. And then negotiation guidance. And mate, it's been really helpful today just to hear from you on a bit more about the states as well and then some stories. I think the biggest takeaway people can have is that when they're listening to this, yes, there's the foresight on SMSF and the mistakes to make. But more importantly, if you're faced with sticky challenges, it's not as simple as you have to agree to the other side. It's not as simple as your way, highway. Like, it's nothing like that. It's like there is a negotiation. There's an art to this stuff. There's a phone call. There's
You're
a
using
letter.
the art word now.
Yeah, I'm using the art word.
There is a bit of an art to it.
Yeah, there's depth. There's
no rules.
There's skills that takes place. And just by having the right people on your side, it can make a big difference. We're very grateful, mate, to have the team at KGCO Legal to have the support for all our clients at InvestorKit and for Acre Financial, mate. So
Awesome.
Thank you for all your work and I appreciate you sharing on this episode today.
Thank you so much, guys. It's my pleasure.
Thank you so much for tuning into this podcast. To hear more like this and to help us spread the word, don't forget to leave us a rating and follow along for our next episode.
Game over.